In the middle of the courtroom, the attorney turns to the doctor and faces him, and with a finger pointing towards him, he says, "And now you have to pay." You want to know what this is about? Come join me on this walk as I share with you this remarkable story. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, this was a medical malpractice trial. I had the opportunity to watch one of the great trial lawyers in New York give closing arguments recently in a medical malpractice case. Now, the defense attorney went first, and he spent about an hour and 15 minutes making closing arguments in this particular case. When he was done, the judge turns to the plaintiff's attorney, the patient's attorney, and says, "Okay, counselor, you may begin your closing arguments." And now he gets up and for the next 2 hours gave his closing arguments. Here's what was fascinating. In the first hour and 45 minutes, he was focused on what the doctor did wrong. He focused on how the doctor lied and covered up certain things. He focused on showing that the doctor's wrongdoing was a cause of this patient's injuries. Now, after an hour and 45 minutes, it became time to show the jury the extent, the severity of this patient's injuries. Now, they had already known and heard testimony about this patient's injuries, but here was an opportunity for him to highlight and to summarize for the jury exactly what this woman went through because of this doctor's carelessness. So here's what's fascinating. After he explains to the jury how this woman's injuries have affected her on a daily basis, he then turns to the attorney for the doctor, and then he turns to the doctor himself and said, "And now it's time to pay." Now, why would he do that? I'll tell you why he'd do that. Because he wants the jury to understand that in our civil system, in our civil justice system, the only thing that we can ask for is money as a form of compensation for all of the harms and losses and damages that the patient incurred, all because of the doctor's carelessness. That's all we are allowed to ask for, and that's the function of the jury. The jury is there to decide whether or not the doctor was careless. If he was, now they have to determine whether his carelessness was a cause of this patient's injuries. If the answer is yes to the first question and yes to the second question, the only thing that the jury then has to answer is, how much money are you going to now give this injured patient for all of the damages from the time of the wrongdoing until now at trial, and how much are you going to give this patient from the time of trial into the foreseeable future? Because now this patient is going to have to live with these injuries and these restrictions and disabilities, presumably for the rest of her life. That's the function of the jury. So now, during the course of closing argument, this attorney turns to the doctor and says in his face, I shouldn't say in his face because the doctor is about 15, 20 feet away from him as he's making these closing arguments. But he turns in front of the jury to the doctor and to the doctor's attorney, and now he says, "And now it's time to pay." Now again, why would he do that? He'd do that because the doctor did not accept responsibility for this patient's injuries. The doctor denied that he did anything wrong. And the doctor also denied that anything he did caused or contributed to this patient's injuries. This doctor never stood in front of the jury and said, "Yes, you're right, I accept responsibility, and because of that, just tell me how much money this injury is worth." No, that's not what he did. Instead, from day one, he fought it tooth and nail. He said, "I did nothing wrong, why are you suing me?" And then he said, "If I did something wrong, whatever I did didn't cause or contribute to this patient's injuries." And then he says, "Listen, if I did something wrong and caused this patient harm, whatever injury she suffered, it's not that bad." Well, guess what? In the course of this closing argument, after this attorney turns to the jury and says, "Listen, it's now time for the doctor to pay," he then proceeded to explain to the jury the value of this patient's injuries. In fact, let me correct that. He gave the jury some suggestions as to what he thinks her injuries are worth. And by suggestions, he even told them, he said, "Listen, you may feel that her injuries are worth much more. You may feel that they are worth much less. What I'm telling you is simply a suggestion." So now, he did that with past pain and suffering, and then the jury has to consider how much longer she can be expected to live. And because of that, the attorney now asked the jury to consider whether this amount of money, a very significant amount of money, would be sufficient to warrant proper and full compensation for all of her injuries. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.